Okay, well, welcome to uh, Local Law Live, a presentation from Lone Star Legal Aid, or sponsored by Lone Star Legal Aid. I'll go ahead and get our disclaimer out of the way. This presentation is intended to serve as legal information only and does not replace legal advice. You can contact Lone Star Legal Aid at 1-800-733-8394 or go to www.lonestarlegal.org for more information on legal assistance. Again, that number is 1-800-733-8394, or the website is www.lonestarlegal.org. So today we are going to be presenting on legal options for domestic violence survivors, but really for anybody who is kind of looking for non-traditional representation. Not just going to your private attorney and signing a representation agreement. What can you do to get legal representation for certain subjects? And today I have with me Mr. Adam Sorholtz. He is the county attorney with Bell County, who handles protective orders for the county. He's been doing that for quite a while now. I also have with me Ms. Brittany Hightower, who is with Lone Star Legal Aid, but formerly with the Texas Attorney General's office, where she worked in the child support division, helping folks get child support and custody established. So we're going to talk to both of them today, sort of about the routes and about the process for going about getting representation at either one of these offices or through these routes. And I'll start with Adam here. And of course, before we do that, you can always apply to Lone Star Legal Aid, where we can, of course, help you with most civil litigation, civil legal services. We don't do criminal stuff. And of course, you can go to that website that we talked about earlier, and I'll talk a little bit more about our process here sort of at the end of this. But let's start with the main events here. And Adam, and Brittany, we kind of want this to be a more free-flowing conversation. So if you guys have any questions or anything like that, butt in and we'll kind of talk about this. But I figured we'll kind of get things ball rolling by going, well, tell us a little bit about yourself, Adam, and how long have you been doing this? And then we'll talk a little bit about the process at the county attorney's office.
Sure. My name is Adam Sorholtz. I'm an assistant county attorney in Belton, Bell County, Texas. I work from 8 to 5, Monday through Friday. Keep an open door policy for all walk-ins that have legal questions about protective orders, whether they be magistrate's orders of emergency protection or family violence protective orders for Chapter 35 of the Family Code. Getting 2-year orders of protection. I do a hodgepodge of other things at the county attorney's office, but mostly my job is to manage the lobby and some walk-in traffic and field questions. And grew up in Round Rock. Went to Round Rock High School, UT, undergrad, taking horns. Maybe we'll win this weekend. And then St. Mary's School of Law, after which I opened a private law practice in Temple for 9 years and then moved over to the county attorney's office where I've been for the past 2. I really enjoy it there. I've got a great boss, Jim Nichols, and supportive cast of investigators and other attorneys to bounce things off of, other avenues of relief. And so I'm really blessed to be here. I have a nice family too, if you want to know about my wife and kids. And we are currently fostering as well. So I've got a lot of irons in the fire, and I'm on my way at the moment to the prosecutor training in Galveston. So I'm joining you from fabulous League City, Texas. Happy to be here today. Thank you, Will.
Yeah, of course. Well, so you mentioned magistrate's orders and then of course the more comprehensive and longer family violence protective orders. Could you kind of tell us a little bit about when would somebody get a magistrate's order, and then when would somebody go ahead and get a longer term family violence protective order?
Magistrate's orders of emergency protection are typically 61-day orders that come out the morning after an arrest for family violence. They have to be issued between the justice of the peace and the defendant that is incarcerated accused of family violence. The application is typically completed by the arresting officer and attached to the booking paperwork at the jail, so that when the magistrate opens the folder in the morning, they see, okay, they're going to set your bond. It looks like you're here on family violence. We're going to set the bond 2,500, 5,000, 7,500, based on the allegations that are in the probable cause affidavit. And then they also, if a peace officer has filled out the application for a protective order and magistrate's order for emergency protection, they can sign off on it. It can go up to 91 days if a deadly weapon was used or there was some serious bodily injury, but typically what you see is a 61-day order. It's a cooling off period. It is without, often without application by the protected party. Sometimes the police don't even tell the protected party they're doing it, and we field those complaints occasionally. We can talk about that later. But mostly it's between the police agency, the justice of the peace, and the defendant who is present in front of the JP. And that's the only time in which magistrate's order can be issued, is while the defendant is in custody in a magistration. And so they're difficult to modify because the defendant's got to come back up and see the JP or get jurisdiction transferred up to a higher court once the prosecution is accepted for the underlying offense. They will typically keep the respondent, the defendant accused of family violence, away from the school that the kids go to, away from the house where the victim resides, and prevent threatening, harassing communication. They do not prevent all communication, and I feel that question a lot, where a protected party says, well, you know, there's something I need to tell them. So you can call them on the phone, and as long as there's no threatening, harassing communication, that's permissive contact. And y'all can even go out to dinner at Olive Garden, have a nice dinner as long as it's more than 1,000 feet from any of the protected locations. At the end of 61 days, those things just go away. They are not extendable, but if there is a need for future protection based on imminent threats, then we will reevaluate as to whether a 2-year order of family protection is more appropriate.
So just, you know, for the clarifying point, if somebody's going, how do I get, and I've heard them called MIPOs, but magistrate's order of emergency protection. How do I get one of those? The answer is just ask the officer who's on scene.
Sure. So there's actually 3 different applicants that can make that in the code. That's under chapter 17 of the Code of Criminal Procedure, 17.292. The magistrate on their own motion could fill out an EPO after reading the probable cause affidavit. They typically don't. Most often it comes from the peace officer. By departmental policy in Temple and Killeen and in Belton, the departments require the officers to fill out magistrate's orders of emergency protection unless the victim explicitly declines or requests that it not be completed. And the third way is if the officer, for whatever reason, didn't fill one out, or the JP didn't do it, and the victim still feels like there's a need for that protection, and the respondent is still in custody, the victim can go to the JP's office the next morning and say, hey, I really need this EPO. But because of the way the jail rotates our JPs at magistration, it'd be really hard to figure out which JP is going to be on duty at that jail magistration the morning after. And just going to your local precinct may not be the particular JP that's doing the magistration of the jail. And so that can be difficult just practically in terms of timing. So the most effective way is to just inform the officer on the scene that, hey, there's been an allegation of family violence. The officer will know that I request an EPO and that I'm, and that'll get you across the threshold.
So then, I mean, so then we've got this typically 61-day period where people get this protection from, this cooling off period. And they go in that 61-day period, they go, man, I'd really like a longer protective order. I'd like, something that's going to go past the 61 days. What is the process then for them to, through your office at least, to look into whether, and I know you guys, similar to us, we've only got so many boots on the ground, so you can't take every case that comes through your door. But what would be the process for having your office look at whether they can go for a longer term protective order for them?
Sure, well, if you don't mind, can I cut in real quick before we move on to the other protective orders?
Yeah.
Adam, this is something, as a former prosecutor who handled protective orders, this is something I've seen handled wildly differently all across the state. If, let's say you have a victim who wants to modify the EPO, let's say they want the respondent to be able, or the defendant to be able to go to the kid's school and pick them up, for example. Is that something your office handles? How would you deal with that?
It is. That is representation that I undertake. I represent the state in those proceedings. But on a written statement from the victim to me, I will prepare a motion to be filed in the assault bodily injury case once our county clerk receives that. So there's typically a 1 week or 2 week lag between when the police agency files the report and the investigation packet with our office for screening to set up a charge against the detained and then usually bailed out individual. Once the assault bodily injury case is filed and docketed, once we have a 2C number at the county clerk office, then I can walk upstairs to Judge Mission, say, hey, look, we've got a letter from this victim here that wants the respondent to be able to pick up the kids at school. It's the protective order as it exists now is unworkable. There is no continuing danger, and modification wouldn't put any of the protective parties in additional danger. And so I just walk those through. I draft them myself. A lot of that is discretionary. I do look at the offense reports. I do look at the allegations as to why it's unworkable, because we get a lot of requests to modify EPOs where it's just like, well, we don't want to pay rent at 2 places. And that's not a great reason to have the respondent home. I mean, it's a financial hardship. That's not quite unworkable. And unworkable is not really defined in the code, but I mean, one of the best examples I gave that I've had come across my desk is CPS was already involved in this couple's life because they had a history of a few domestic violence incidents, and they required mom to move to grandma's out of county. And so she had to take the child to a different city a couple hours away. And Bozo, the respondent, got EPO'd from the house, leaving behind a couple of goats, a couple of cows, a couple of chickens. There was livestock, animals to feed, horses, dogs, cats, the whole 9 units on this working farm. And he says, look, somebody's got to feed these animals, like otherwise we're going to have animal cruelty problems on our hands. So we did a modification straight away in that regard because mom was driving back and forth hours, practically every other day just to keep these animals going on the working farm. So that was unworkable. Unworkability is an unusual beast, but typically it's not just because it's financial hardship. I mean, we're looking for other factors as to why, and they could be employment related, they could be healthcare related for either parties as to why the current protective order is unworkable and necessitates modification. Because in general, the state is in favor of the cooling off period. I mean, nothing ever comes. We don't ever catch any flack at the prosecutor's office for maintaining the status quo once people are already separated, that no further harm can come from the continuation of that separation. And it's only for 61 days. I mean, life is tough. You'll get over it. You'll get past it.
It was a good question, Brittany. It made me think of another one, which is, and you kind of mentioned it, and I think, Brittany, you might be able to speak to this as well, which is just for people who may be watching this who are not in Bell County. Is this process approximately similar across the state of Texas, at least to y'all's knowledge? If somebody, in Austin or El Paso is looking at this, are they going to be able to go and talk to their police officer, or, can you guys not speak to that? I don't know the answer to that myself.
I will say the core of what Adam was describing, that who can request it, when the magistrate makes their decision, that is the same, because that's all based in the code. In practice, how that works out is wildly different. So like in Travis County, we had 24-hour magistrates, like 24-hour, they were special employees of the city. That's all they did. That was their entire career. So it wasn't like they had to go be a JP afterwards, or they were reviewed by a district judge. I have practiced in counties where they don't have anybody who's there over the weekend. So they have somebody who will come in for a few hours, like on a Saturday morning or Sunday morning, to meet that 24-hour requirement for a misdemeanor arrest and get them magistrated. But there's nobody there besides that one person processing these people for an hour. So the victim won't be notified until Monday morning when somebody comes in. It's wildly different depending on the resources and how much the people who are in charge of that process really care.
Awesome. Adam, any thoughts on that yourself?
Yeah, I mean, that goes back to what I was saying about the rotation of the JPs. We have 6 justices of the peace in Bell County. They usually take a week here and there. They separate the duties out for magistration. And so, this week it'll be JPA's week, and then next week it'll be JPF's week, and C and B and A and D. And so they kind of swap those weeks around. And typically you have to go back to the JP that issued the magistrate's order for emergency protection to get it modified. It's filed in their court. They don't have concurrent jurisdiction in other JP's dockets or in their records. And so that can be a rather daunting task. And if that's why it's very helpful to have the assistance of a county employee looking at this and knowing all the intricacies of the moving parts to figure out, okay, what's the best way to get this done? What's the most efficacious way, the fastest way to get it done? Because there's a lot of moving parts in inside baseball to getting that modification accomplished. That's difficult.
Now, I guess let's kind of, unless you you have any other additional questions here, I'm thinking let's try to talk a lot about the big guy here, the 2-year protective order. That's we get a lot of applications to Lone Star Legal Aid for protective orders. I know Brittany handles lots of protective orders for us, but I think Adam, can you still hear us? It looks like we may have. Oh, there you are. Okay. You're cut out on us there for half a second. No worries. Okay.
The joys of technology.
Always technology.
Sorry, I missed the last 20 seconds. Can you repeat the question?
No worries. I was just going to say, let's talk a little bit about longer protective orders if we can. What is the process for if somebody wants a 2-year protective order and they want to go through your office to get one? Who are the people that you help, and what is the process by which somebody can ask your office to look at helping them?
Screening question. Can you hear me all right now?
It's a little faint, but we can understand you.
I'll lean in. How's that?
Yeah.
Any better now?
Yeah.
Yes.
Okay. So we have a screening questionnaire. It's about 7 pages that we use to collect information that we would need to file a lawsuit. Protective order of the 2-year variety is a real lawsuit, just like many other lawsuits with a plaintiff and a defendant responding. And so we need a lot of information to collect data that would allow us to make a good decision as to whether it's a viable cause of action, and also to provide the most robust protection of the applicant and children or other adults that might be protected by a protective order. So versus gathering information about the applicant, the plaintiff, demographics that go into that, social security number, race, their employment, that's going to be a protected address, that's always important. And then we inquire about the nature of the relationship to the respondent, how long that's been going on, whether there are children in the household, other children from prior relationships, other adults. And then we inquire a lot about the respondent, where they work, where they live, if they're living separately, what kind of personality traits they have, what kind of criminal convictions or other legal matters they might have going on in their life that would inform us as to what the best avenue of protection is. And then we get down to the merits. Through the history of violence, often referred to as like a timeline of violence. And we look at a lot of factors that lead up to violence, like harassment or preventing contact with friends and family, taking the phones, other property issues that might come into play. And then last, we look at how law enforcement would best be suited to affect a protective order. What would that reality look like in the future? What the remedy is that would be best capture all that. So we collect that information on the front end. That's necessary for us to make a decision as to whether or not we will accept the protective order. That is filled out by the applicant, typically in our lobby. We have a private room that victims of domestic violence can come in and sit with one of our legal assistants who has a lot of experience in helping make these decisions and help them fill out the forms. And then if they meet our first test, then we'll take an affidavit from them and begin drafting the application. We use the standard Supreme Court forms along with others that we keep in our office to make the very generic application to the judge, and then we go through it and we tailor the remedies specific to that so that they get the best relief possible, so that we can effect maximum amount of protection, and the law enforcement and the constables who serve it, as well as the police that might be called out to the scene if it's violated, are in the best position to provide effective enforcement of that protective order in a way that is a deterrent to the respondent, but also is because the maximum amount of pointy end of the stick on the back end, so that we can really put the screws down if it becomes necessary.
Just to piggyback on that real quick, I have a little saying that we developed when I first started doing protective orders, that we have three kinds of respondents. The first kind of respondent is so terrified of going to jail that as soon as the order is issued, they follow it to a T, and they follow it to a T until the day it expires. The second kind doesn't really take us very seriously, and so they kind of like to test the waters, and once they get arrested and go to jail for that first text message, phone call, whatever violation it is, after that they follow it to a T. And then I have my third kind of respondent that just really seems to like being in jail. And I developed that little system after I had one guy where he literally got out of jail, walked across the street from the Williamson County Jail, found a payphone, and started calling her as soon as he walked out of jail after being arrested for like his third violation of protective order.
Golly. So this is actually a question I don't know the answer to. I'm showing my ignorance here today. When, Adam, when your office, and you might be able to speak to this too, Brittany, when a prosecutor's office represents somebody for a protective order, are you the attorney for the applicant, or are you still remaining the attorney for the state?
I love this topic. I have a lot to say about it, but I want Adam to go ahead and answer first.
We represent the applicant. Go, Brittany.
So Adam and I actually had this conversation when we first met, and we are of like minds on this, that the way the code is written for protective orders, whether you work for a prosecutor's office or you're a private attorney, you are their attorney. It's very clearly written that way. As strongly as I feel about this, and Adam completely agrees with me on this, there are people who see it differently. And there are a couple different counties, at least, where they operate as where the county attorney who's representing or filing the protective order on behalf of the victim represents the state and the state's interest. Again, I don't see anywhere in the code where that is a thing, but there are several large counties that operate that way, and that's the way that they approach it. I think the biggest rationale for that is, one, you have a little bit more control over your application when you have a victim that's absolutely terrified. So you can subpoena them, you can kind of force the victim to go forward. I personally have a strong philosophical disagreement with that approach, but that's the way some people do it because they think the protection is really necessary. I do see the rationale for that. The other reason for that is to avoid a potential conflict of interest. So in some counties, like for example, in Bell County, the district attorney's office represents CPS in CPS proceedings. But in other counties, for example, in Williamson County, where I used to work, the county's attorney's office handles both protective orders and CPS litigation. So you may very well have a victim who comes in contact with your prosecutor's office as a result of CPS opening a case and removing the children. But that person, the only reason they have a case is due to domestic violence, and that person needs assistance. And now that CPS is all up in their business, they're ready to access resources and get help so they can escape this relationship. But now you've created a conflict because you can't both sue somebody to take their children away and represent them in a protective order when the same facts form the basis of both of those cases. So I think that's why some prosecutors' offices tried to adopt this "we represent the state" model. There's very little case law addressing this issue. I've talked to a couple different prosecutors around the state who were involved in some of those appellate level cases, and they went back to the direct representation model, realizing that they couldn't get around this, or they've developed a referral program with their local legal aid office, so that way they could just boot those protective order cases out. But it's an interesting conundrum. I much prefer the way that Adam and his office handles it, and then just kind of refers cases to us if they run into a conflict.
I had no idea when I asked that question that I was putting my foot into such a ramble patch there. I would have never have guessed that was an issue that had so much conversation about it. Geez.
It's any prosecutor's office who handles protective order, if they've put a little thought into it, has dealt with that issue and tried to figure out how to deal with it. Again, I think Bell County has the best model, where CPS representation is a totally different office. And then Adam and his team, they directly represent the applicant. And if there's a conflict due to a criminal case or something, they just decline representation and make a referral to us. It has been the best model I've dealt with across the state, for sure.
Well, kudos, Adam. Well done. I guess, so kind of just recapping there, if somebody wants a protective order through the Bell County Attorney's Office, they go to you, you have a form that they'll fill out. Now, do the applicants for protective order who are, and we're kind of getting a little bit, maybe a little bit confusing here with the language here, because an applicant is the technical name for somebody who is pursuing a protective order in court. But what I'm talking about are the people who are applying to your office for potential representation. Do they have to have been the victim of a crime in Bell County? Did the respondent have to have been arrested in Bell County, or can they just come to you and allege family violence and ask your office to step in?
The last. And so there are so many different ways for us to have venue over the matter that it is very easy for the county attorney's office to accept any applicant, even if you're on a cross-country road trip and the violence happened in Bell County, and where you can apply for a protective order here. Practically, for the reasons of getting the respondent served and returned to court and enforcement, very often we try not to get involved in out-of-state or even out-of-county protective orders unless it's really necessary, unless there's a direct threat to a resident of the county from an outside area. I mean, we try not to, though often we do, get complaints. Somebody from Missouri is threatening me, somebody from New Jersey. I've got, an ex-boyfriend in Houston. Every time he comes up to pick up the kid, he punches me in the mouth. And so we do cross-county lines service and respondents like that. Our success rate on getting those across county is lower than our success rate in county respondents, and our success rate out of state is dismal. I mean, it's just so hard to get services processed outside the state when not all states provide free processing service, for example, for protective orders. And so that can be a challenge. But to answer the question generically, practically anybody can apply. You've got a family or dating relationship or a household relationship with the person against whom you are requesting protection from, and you happen to be in my lobby, we'll find a way to get jurisdiction and venue.
Awesome. Well, I see that we are hitting here at half an hour. Honestly, I'm glad we had the amount of time to talk here, but I want to be respectful of y'all's time. So I do want to kind of move on to talking a little bit about SAPSTers here, if that's okay. Adam, do you think there's anything else you want to tell the world or tell whoever may be watching us right now about the protective order process in Bell County?
Well, as you migrate over to SAPSTers, let me say that our interest is not in remaining in family law litigation for the long term. The protective order process is designed to be started and completed, in theory, if we get the respondents served quickly, within 20 days. And so we get in and we get out. We try to get the protective order, strike while the iron's hot, and move on. We don't like to linger in family law litigation just because of the potential conflicts of interest that Britton was discussing earlier. We don't like to stay around as people's private attorneys any longer than we absolutely have to. And so we are a very effective office. We have a lot of resources available through our investigators and staff that we can lean on at the courthouse and at the JP's level. And so we get it done quickly. We usually get it done right. But when it migrates over into family law, and there's divorce proceedings coming down the line, and temporary restraining orders after that, and custody arrangements, and SAPSers, at that point, the county attorney's office is usually trying to backpedal out of the litigation and find a way out, because we don't like to linger around and get into custody fights for folks. I mean, we're there for your physical safety, not for your, deciding who the best parent is.
Gotcha. That makes sense. Family law litigation, as I'm sure everyone here is aware of, and unfortunately probably many of our audience is aware of, is a time-intensive and emotionally draining process. I can understand wanting to get out of that and not put your foot into it as much as possible. And it makes sense from the perspective of your office, just to go in there, get the protective order. That's your job, and get out and not have to, belabor the point. But for people who are looking for, that if you're looking for a protective order, sounds like the county attorney's office is definitely a good route to go apply, see what they can do to help you. For a lot of people, protective order helps. And even the second step after a protective order is, now I need to go and figure out what I'm going to be doing with my kids for the long term. How am I going to be handling this this relationship as far as exchanges and what decisions can I make? And so now I need representation, of course, for a custody order. Now, we were using the term SAPSer earlier. That's a term of art. My client. I'm getting a little bit of feedback here. I explain this to my clients pretty frequently. The SAPSer stands for suit affecting the parent-child relationship, and it's just sort of what the colloquial term is a custody order. That's the common term that people use, but the phrase that the code uses to refer to that particular thing is a suit affecting the parent-child relationship. So I kind of want to now turn to Brittany and, kind of pick your brain about your experience in the Texas Attorney General's office, where you worked for quite a while. This is a place where people can go. Well, I'll kind of actually give you the floor and kind of tell us, what is the Attorney General's relationship with SAPSers?
So that's an excellent question. So the most important thing people need to realize is that they do not represent anybody involved in the lawsuit except the state of Texas. So when people are applying for services with them, they're applying for child support services, but they're not applying for an attorney to represent them. Unlike Adam's office or some other county attorney's office in a protective order where it's an employee of the government, but they're still representing you as your attorney and they can advise you, the Attorney General's office is not advising anybody or representing anybody's interests other than the state of Texas. The state of Texas has an interest in ensuring that children are supported. And this, I could give you a week-long spiel about this, but basically it comes from a federal government law that orders different states to create a office that's in charge of establishing and enforcing child support orders. Texas is unique in that we're the only state that our family code actually requires the Attorney General's office to obtain custody orders or orders for what we call conservatorship and possession. People think of as legal custody and physical custody for the children at the same time as they do child support orders. So the state only has an interest legally in ensuring that the children are financially supported. They don't have any interest in the custody provisions. So it gets a little bit tricky because they're required to ask the court to establish those orders, but they can't argue one way or the other for them, even if it's in a particularly egregious case. For example, if you have a situation where one parent's been arrested for sexually abusing the child, the assistant attorney general can only present the case as, Judge, we're asking for this in terms of support, but we're leaving it up to you to make whatever decisions in the child's best interest. We don't take a position on that one way or the other. So sometimes people get confused because in the past they used to represent the custodial parent, but that's no longer the case. They just represent the state's interest. But otherwise, the process kind of functions about the same as you would see in any other custody litigation, except most parents don't have an attorney. They're self-represented. And so it would just be the state's attorney and then the two parents there in front of a judge or negotiating before they go to court on the child support and the custody provisions.
Now, will, one of the things that, and I imagine this might be handled differently, maybe even between attorney general's offices, but just to kind of link to Adam really quick, if somebody comes in with a protective order, does that affect at all what might occur at the Texas Attorney General's office as far as representation goes, or what they're looking at as far as getting the SAPSR?
Absolutely. So there's essentially two complete separate tracks within the Attorney General's office. And I think different offices, different regions might handle it differently, but they have a very, almost a military level organization of hierarchy and rules from the top down. And they're, by and large, offices are pretty consistent. At least the region I worked in, offices were pretty consistent about how they handle it. And so if the case has been flagged for family violence, which could be for a variety of reasons, but definitely if there's a protective order, it's going to be handled completely differently. There will be no interaction between the parents. The information about the victim's address or phone number or the child's is going to be kept confidential. It's just handled completely differently. There's just a level of care and attention that's paid to it that's just not required in other cases where the case has not been flagged for family violence. So again, I will say if somebody is going through that process, even if they have a protective order from a different person, let's say it's their ex that was very abusive, but now they're going through child support process with the father of their current children, and they get along great, everything's fine, they're just not together anymore. The Attorney General's office still needs to know about that because there are certain precautions that they need to take in order to protect your information and potentially protect the father of your children as well from this abusive ex-person.
Now, so we kind of learned a little bit about, and I know, you now work with Lone Star Legal Aid. And so, you can speak with authority here. I think probably about both things, but definitely about the current process for LSLA. But I imagine you're still familiar with how would one go about talking and getting in with the Attorney General if they want to go and get a child support order put in place. How does that happen?
If the person who wants to apply has the computer skills and the access to the internet, or a friend or a family member, somebody who's willing to help them do it, apply online. It is infinitely quicker. I just cannot state that enough. Other options are they have a 1-800 number where somebody can call and try to do it over the phone. At the risk of publicly throwing the call center under the bus, for various reasons, I just don't recommend going that route. And then also they have paper applications. So you can call the 1-800 number and request that they send you a paper application, or you can go online and request a paper application be sent to you. That's an equally valid way of doing it. It's just going to take a lot longer for you to fill out the paperwork, mail it off to the state office, and for it to be processed. Whereas it takes a couple of weeks for it to be processed if you do the application online. And just a little bit about the way that they go through the process. The state office will review it and just kind of make sure they have what they need, make a referral to the local, the offices that actually handle those cases. And then a child support officer is usually going to contact the person who applied, make sure they have all the information correct, ask for any follow-up information that they may need, police reports, protective order, birth certificates, acknowledgement of paternity, things like that they may or may not have access to. And then they're going to either set it for a child support review conference, which everything's virtual now, so it will be done by Zoom, or they're gonna, if it's a family violence case, they're gonna immediately send it to the attorney to file and get it set for court. And then both parties are gonna be served.
And does the AG's office, do they accept every case that comes?
Every single case. They are required by law that if somebody applies and there is a valid case to be had, they are required to accept it and file it. The only time I have seen cases not go forward is where they get a refer. So for example, they'll get a referral. So if somebody, there's two ways that they get cases. One, somebody applies, and that can either be the custodial parent or the non-custodial parent, or somebody who has the children and is not a parent, or they get a referral from HHSC. And they're going to get referrals from HHSC where a person has applied for TANF, formerly known as welfare cash assistance, or Medicaid for themselves and or the children, and the other parent is not paying child support. There's not an existing child support order. So they're going to get a referral from HHSC. And different regions have different policies on this, but if we would get a referral from HHSC and nobody had applied in that particular case, and it was clear that there had been either sexual violence towards the custodial parent that resulted in the birth of this child, or pretty severe family violence, we would refer it back up to our supervising attorney for the region, and they'd make a final decision about whether or not we could close out that case. Other than that, the only time I've seen them turn away cases is where somebody applied and there's just nothing viable. Let's say the child is over 18 and they're applying for past child support, or it's clear that the other parent is only receiving SSI, which isn't considered income for child support purposes, but they don't want any custody orders. Then at that point, they're just going to say, well, we're not going to do this because we're not going to produce any results for you. But otherwise, they'll file everything.
Let me pause here. Adam, are you thinking any questions that you can think of about the AG process? You may be more familiar with this than I am. I'm learning stuff here from Brittany. I'm glad I'm getting a chance to talk to you about this.
No, I mean, I'm also learning a lot about the AG process. I know that they have a special track for red flag cases where there's been family violence, and that some of the work that I do goes into the decision to backtrack or set aside on a separate docket those cases and protect the applicant by, for example, not disclosing their home address, keeping some information confidential, or modifying the possession order so that for example, the custody exchanges are done at a police station rather than the residences. That's all stuff that we take into account when we do the protective orders, but the SAPSers are definitely downstream from where I'm looking in most cases. The protective order process on occasion does keep the respondent away from the children for a short period of time if they don't go and get a new SAPS order, but just like any other district court order, the last in time order controls. And so when I go out and I take a protective order and the respondent concerns, hey, you're severing my parental possession, I say, well, you know, go take it up with the AGs if you're not on child support, and you'll immediately get a new possession order. So that often releases some pressure off of that valve to take seek a redress on the possession and custody orders, either in a SAPS in the district court or through the AG's child support division.
Just to piggyback on that, that is such an important point, Adam, and I'm so glad you made that, because I've run into that a lot of times with law enforcement getting confused about this. So for example, if I had a case where there's an existing custody order where dad has standard possession, meaning the every other weekend essentially, visitation with the kids, and then a protective order is issued where the children are named protected parties, but the only provision that really applies to them is, let's say, no threatening or harassing communication, and dad can't go pick them up from the school. Well, I've had situations where law enforcement goes to enforce the protective order and is saying, well, there's nothing in the protective order that says dad can be around the children. And it's like, that's not what a protective order says. The protective order only restricts, it doesn't define what the additional provisions are going to be. So it's just going to be what the custody order says, minus any limitations the protective order had on it.
It is a negative order. It is not a positive order. It does not create any duties. It just restricts abilities that would otherwise the respondent would have the liberty to do such things as contact his ex.
Perfectly said. Yeah.
Now, this, I'll just clarify this because I think, sometimes, the waters can get a little bit muddy, especially when we're talking about the legal stuff. Brittany, a Texas Attorney General will not do a divorce for you. Is that correct?
Absolutely correct.
Right. And Adam, a protective order is not the same as a divorce, and it will not, you guys won't represent anybody in a divorce, correct?
This is an important point. A protective order is a very useful tool in a divorce. And if you have grounds for it, it can be a great kickoff to a divorce proceeding because it immediately puts the applicant possessor in a terrific position, get the abuser out of the home, and so they can collect their things and handle the property disposition and a lot of the other stuff in the divorce in a more level-headed and in control manner. But specifically from the county attorney's perspective, we don't want to get involved in property disputes. We don't want to get involved in custody disputes. And so we try to stay out of that stuff. So I will point out that if you think you have good grounds for a protective order based on a pattern of violence, and you're also thinking about a divorce, it may be worth your dollar to go to a private attorney that will wrap that up into a single vehicle, although a protective order is a separate application from the petition for divorce, but put that all in on the same day at the clerk's office and really strike hard, and that would be the best lead off to a very favorable and advantageous divorce. But that's just curbside advice. I can't speak for what the county attorney's office would do because we don't touch property, we don't touch cars, we don't, that kind of stuff. It's not our business. We're just there for the physical safety of the person.
I will piggyback up on that too. Although Adam makes a very good point. That is something that isn't technically available in a protective order. The protective order statute does allow the judge to include additional orders that would reduce the likelihood of future family violence. And so it's possible that the judge can order exclusive use of a vehicle or include visitation with the children or things like that. For various reasons that I think Adam's already touched on, like the potential conflict of interest, limited resources, things like that. It just gets real messy when prosecutors' offices are trying to handle that kind of stuff in a protective order. They just don't have, they're just not really in a position to be able to fully explore the issues to the extent that are necessary to try to handle visitation issues and use of the vehicle. And it's just, well, you touched on this before, these can be long drawn out ordeals, and the prosecutor's office is there for immediate safety, get the order issued, be a little bit creative with it if it's necessary, but otherwise not get involved in protracted litigation for trying to deal with stuff that's not really part of their purview. So that's something, again, a private attorney or somebody at legal aid, we could be a little bit more expansive in what we're doing.
I've even had judges in Bell County, go, Mr. Rod, I don't want to talk, I don't want to get into issues regarding custody, visitation, property stuff in a protective order hearing. When I've gone and brought up a protective order hearing, they said, look, there's other litigation where we're going to have more, time to get more evidence in front of us to make good decisions about that. Let's not be doing it here in a protective order case. I don't think that's, by any means a rule that they had. I think that was probably a, particular case. But just like Brittany said, I think that if it will decrease the likelihood of violence, I think that's going to be something that's going to convince a judge that that is necessary. But it is not by any means, a protective order is not by any means a backdoor to getting a SAPSER quickly or, trying to get possession of a car. That is not the purpose of a protective order.
There are some judges who have very strong feelings about that I practice in front of. Very strong feelings.
Right.
I will point out that just in Bell County, we have a wide array of judges' opinions on these matters. And there are some judges that would, in theory, entertain a request for spousal support as a protective order condition, which is just over the top, in my opinion, a wild theory, but it is authorized by law as a way to protect the applicant. And so that there is a wide variety of judges that have been elected and appointed in Bell County that are willing to entertain a variety of issues. And so that just consult with the lawyer, figure out which one you're going in front of and what the best avenues are.
And just as a side thing here, I tell my clients this all the time, and I'm sure Brittany and Adam, you guys can echo this. It has just been, I've only been practicing, you guys have been practicing, I think, far longer than I have, but it continually surprises me how often, what judge you're going in front of can influence what the relief is that you're going to get. when I was in law school, I thought, oh, the law says this, you bring a case, you prove this, you're going to get the relief that the code says. And that is just not been my experience. And so I just constantly am telling my clients, just know, if we go in front of Judge A, we might get this. Judge B likes to see these things. Judge C does not like to see these things.
Exactly.
Yeah.
That's
Without
good
naming
advice.
names, absolutely. Correct.
Absolutely. And it's funny. I in addition to working for the Attorney General's office and being a prosecutor, I worked for Texas Advocacy Project for several years, and we practiced statewide. So I have been in court everywhere from north of Denton to far east Texas to Midland, Odessa, Travis County, all the way down to the valley. And that is the one thing that is absolutely true universally across every place I practice is it just depends on your judge.
Now, Adam, I guess let me ask you, do you have any questions about Lone Star Legal Aid or any of our processes? I'm going to kind of give, I think we're entering our 8-minute countdown here before they're about to kick us off of our stream here. So I want to just give a brief overview for people, but do you have any questions for us that we can answer?
What's the income threshold? I got a protective order applicant that also needs a divorce, and she works as a waitress. I mean, what's the income threshold that's I can tell her, you better start here with a protective order, or no, go ahead and head straight over to Lone Star that you'll probably qualify with.
So what I typically say is it is 150, Brittany, am I right? 150% of the federal poverty income guidelines. However, we can go up to 200% given certain exemptions. And so and these are things that we can typically, now we can't, say for sure that we're going to be able to help anybody who is 200% above the federal poverty line or not. But, typically I tell people just as a good baseline that 200% is about where we can usually do. Brittany, you may want to step in there and take my foot out of my mouth if I.
It's 100. So across the board is 125% of the federal poverty guidelines. We can go up to, I only because I have my chart right in front of me. We can go up to 187.5% of the poverty guidelines under Crime Victims Civil Legal Services. And then for certain grants, so like I serve survivors of sexual violence. So for my grant, we can go up to 200% of the poverty guideline, but we have to have certain income exceptions. And then there's the asset requirement as well. So I always tell people those rough numbers, you can kind of look them up, but really the best bet is unless you've got somebody who's comfortably making $60,000 a year and owns their own home and has multiple cars, probably not going to fit within our exceptions. But absent somebody on that level, it's still worth it just to send them to us for us to screen them, because there's just so many exceptions and it gets real complicated.
Thank you for putting the real numbers out there. I'm sure my boss is going to come to me later and go, William, you need to learn those things a little bit better before you go spouting off.
Just keep your chart with you. That's the only way I stay out of trouble.
I have one more. So I don't practice much under the Code of Criminal Procedure for sexual assault protective orders or stalking protective orders. I'm spectating a case in the coming weeks where the Texas Advocacy Project down in Austin is seeing through a sex assault and stalking protective order through the Code of Criminal Procedure. Typically, everything I do is under chapters 81 through 85 of the Family Code for just repetitive victims of domestic violence. And so I'm wondering if Legal Aid has had any experience under the Code of Criminal Procedure for going after stalking protective orders or sex assault protective orders without a conviction, just on the plaintiff's testimony.
I do a ton of them. I have gotten them granted where I've had no criminal charges, never made a police report. It's harder. It really depends on the applicant. So when I'm screening for them, if I have an applicant who qualifies under both the Family Code for family violence and sexual assault, we talk extensively about what this looks like. Let's walk me through the day when it happened, what's going on. And then also I explain to them, there's a real possibility you're going to have to sit in a courtroom in front of a bunch of strangers and be cross-examined by the person who did this to you, potentially for 45 minutes plus. Are you in a place where you are ready to do that and to talk about it that extensively? And a lot of times people say no. So I let them make an informed decision once I've decided that we meet the legal threshold. It's really about how detailed and consistent they can be in describing what happened to them, what this person did to them, when I will make a decision about whether or not to take it. I mean, but because oftentimes there just is no other evidence. I mean, I've done several where, I mean, she made a police report and it's a pending investigation. So law enforcement's not going to give me anything. Scott and White's not going to give me anything. I can't collect any of the evidence that's out there. And they're due to COVID or for various other reasons, we're not going to see an arrest for 6 months, but this person is still showing up at her work, coming by her house, knew where she lived. So, and it just didn't meet family violence grounds. So I've filed a couple of those there. And I've had varying levels of success. I've had some judges where I was really concerned and kind of, didn't think that they would go for it. And all I had was my applicant's testimony and the respondent making some really unfortunate for him statements on the stand. And, judge granted it for quite some time. So
I've done several of them. I've never done a sexual assault, but I've done stalking many times. And I typically plead in the alternative. Usually there is, if there's stalking going on, if there's harassment to the level where protective order is going to be necessary, there's usually a history of family violence. And again, family violence can be a threat that puts somebody in fear that they are going to be, assaulted or. And so a lot of times, that is the way that I'll go and I'll have it, granted as both a Code of Criminal Procedure protective order and a Title IV protective order.
A couple of things that I just wanted to clarify from the county attorney's office. We don't have a whole lot of experience in that realm of stalking and harassment protective orders. Second is that if the protective order applicant is seeking a kick-out of a member of their household as part of the application, what our judges are looking for is blood on the ground in the last 30 days. And third is that while by definition, threats to commit family violence constitute family violence, really what we're screening for is injuries. We hear a lot of stuff, well, he's just mean, he calls me this and that, and says he's going to do this and that. And we don't have a prior incident that would constitute family violence assault that would be an arrestable offense in the eyes of law enforcement. We're probably not going to take you up on a hot talk protective order. He's just mean all the time, and he always said he's going to beat me, but hasn't happened yet. The county attorney's office probably will not step in at that point. So our best bet at that point is to either move out or seek a divorce or have to seek alternative relief, not through the court. The protective order.
And sort of on that note, those are the things that Lone Star Legal Aid might be able to help. If you qualify, as Brittany was saying, for our income and our asset thresholds, and that is, just a process of being screened by our intake workers. You can apply online. You can apply again at the number that I quoted earlier. That's 1-800-733-8394, or at www.lonestarlegal.org. We'll ask you some basic information, sort of same as Adam's office, same as probably you would give to the Attorney General's office. And we'll look at doing a divorce for you. We'll look at doing a SAPSR for you. We'll look at doing a protective order for you. We have not always the same restrictions that somebody who is coming out of a governmental agency may have to work under. With that, I guess any closing comments from Adam or Brittany? Anything?
No, I think the main thing is just to, again, and we've touched on this quite a bit, but to recognize the limitations of what each can do. Miss being a prosecutor because Adam has access to a whole bunch of information that I would love to have again. But again, we have a lot more flexibility in the kinds of relief that we can help somebody address. I've definitely had somebody come to us for a protective order, and after screening it and working through it, realizing a SAPSER is going to better meet that person's needs. And there's just some tools that are just not available to a prosecutor's office. So again, being mindful of the kind of assistance that you need and the limitations of each of us.
I would encourage everyone to donate charitably to their local family violence shelter, the women's advocacy groups, the Advocacy Project. Here in Temple, we have Aware Central Texas that refers me a ton of cases. I really appreciate the
Great
work we do.
organization.
Legal Aid also accept your donations. So please give generously if you're watching online and find a way to donate to one of those agencies that have been mentioned here in today's podcast.
Well, thank you guys so much for being here and for doing this and for sharing all of that information. I hope that, and I can't imagine it wouldn't be helpful to somebody who is watching this. Thank you for your time, Adam, and thank you for your time, Brittany.
Thank you.